Q&A session. We are going to be answering questions first that have already been submitted. A few questions have been submitted, so we'll take care of those questions first, and then we'll open up the floor for any additional questions that you guys may have. So that's going to be the order of business. I will give about a minute or so, a minute or two. We'll start rolling at about 7:03, just to give a few more folks time to come in, and then we'll go ahead and we'll get started. Thank you again for being here, and always like having these Q&As. Like to hear what you guys are thinking, answer your questions. So excited to be here. Thank you. Igor, you can introduce yourself as well.
Hello, everyone. My name is Igor Belkin. I'm associate attorney with Sharline S law firm. So I would like to also thank you for your interest, and we will be happy to answer all your questions, and we will be glad to assist you with your family estate plans.
Wonderful. All right. Hopefully everyone can see the screen here. If you can, just give a little nod. All right, so like I mentioned earlier, it's our mid-year estate planning Q&A session. And we've already introduced you guys. This is our first question. Will assigning beneficiaries alleviate the need for a will? And before we start, we'll just take turns. Igor and myself will take turns answering questions. So this first question is about assigning beneficiaries and will that alleviate the need for a will? And the simple answer, well, it's a yes or no answer. So for those, there's some assets that can transfer by beneficiary designations, quite a few assets actually. Your bank accounts, pretty much all of your financial assets like bank accounts, checking savings, money market, mutual funds, CDs, all of those types of assets that you would sign up for at your local bank, you can transfer by beneficiary designation. All you need to do is go to the bank and ask for what's called a POD form, a payable on death form. That form will allow you to designate a beneficiary. I always advise my clients to designate more than one. Designate a primary beneficiary, and then of course you want to designate a backup in the event that something happens to the primary beneficiary. Because if there isn't a beneficiary if you've listed a beneficiary and they've already passed away, the asset's still going to go through your will. The other assets, like of course your life insurance, your retirement accounts, brokerage accounts, those all, of course you can add beneficiaries to. Your brokerage accounts, your normal broker-driven accounts can also be, you can also add a beneficiary to with what's called a transfer in that form. So all of those financial assets you can. The assets that you don't necessarily add beneficiaries to are things like, your real property. There's not really a way to add beneficiaries to it unless you do like a joint tenants with survivorship. That's not necessarily appropriate in all circumstances. So while there are a lot of assets you can add beneficiaries to, of course, there are a few that you can, and it's always a good idea to do estate planning to ensure that you're covering your bases.
And before answering this question, I would like to add to Sharline's answer for the previous one. So I just want to add that in general, beneficiary designation is a great estate planning tool. It allows you to avoid probate, and beneficiary of your asset will receive everything in case of your death outright without any delays. However, you need to remember that it's not a great idea. Actually, it's a bad idea to designate minors as beneficiaries of your assets. It's a bad idea to designate someone who has special needs as beneficiary of your assets, because sometimes, and unfortunately, we worked with these cases when, for example, special needs beneficiary was designated as beneficiary of life insurance policy, and payment of like a few $1,000s just disqualified that person from governmental support, and it doesn't make sense to do that. So you need to remember that in general, that's a great tool. However, there are a lot of exceptions, and minors and special needs beneficiaries are these exceptions. And moving forward to the next question, does my family still have to go through probate with a will? The answer is yes. So when you have, even when you have your last will and testament, beneficiaries of your estate will have to go through probate, and the person who was named as executor of your estate will have to file petition to probate a will have to file the original of the will and go through this procedure. Yes.
Wonderful. And keep in mind that when the purpose of probating the will is really to validate the will. So that's what the court's doing when they're looking at the will. That's why you present the will to the court, they ask your heirs and to weigh in. So if you have a will, you absolutely have to go through the probate process because the will has to be validated. You can't do anything with the will until the court says, yes, this is a valid will, your executor can go ahead and carry out the terms of the will. So yes, absolutely, you do have to go through probate with the will. Let's see here. Next question. I need to learn more about trusts. Are they better than wills? I'm 61 and need to learn. So there's no real easy way to go through all the differences between a will and trust. I've done a few, at least once a year. I think I've done at least 2, maybe 3 seminars where I've devoted to just going through the differences between a will and a trust. So certainly we're not going to highlight all the differences here, but whether it's not necessarily whether it's better than whether the trust is better than the will, it's more of what fits your circumstances, your family circumstances better, what is going to be best for protecting and providing for your family. So in some instances, a will is perfectly fine. Georgia is actually a very probate-friendly state. So compared to your more highly populous states like your Californias, your New Yorks, your Floridas, those states you want to stay away from will if you can, because going through the probate process, remember we said if you have a will, you have to go through probate. And so if in those states the probate process are much longer, that's usually a deterrence from doing a will. In Georgia, you can get through the probate process in 6 to 9 months, if all things go well, no objections, no the process is streamlined here. They make it fairly probate friendly, the forms that you have to fill out. And so, depending on your circumstances, adult children, everything, outright distributions, a will may be perfectly fine. In a lot of instances, a trust is a wonderful tool, wonderful organizational tool. And certainly if 6 to 9 months may not be, acceptable for your family. So if you want to avoid that process, then certainly you'd want to use trust over the will. But it isn't a one size fits all. You really do want to look at what's best for you. In your case, in this, the person asking the question says, I'm 61. So typically when you're thinking about estate planning, you're really planning for the folks that come after you. So it's really about the beneficiary. So you want to think about what's best for them. 61, your children are probably adults. So, whether you need a trust or will, it's going to just depend on what your circumstances are. But at 61, you are going to want to think about long-term care planning. So that's a part of estate planning or elder law planning that we want to bring into the process and we don't want to forget about. Long-term care plan is very important. Of course, the trust and the will deals with disposing of your estate after you passed away. Long-term care planning thinks about how you will pay for care in the event you're ill or have a prolonged illness prior to passing away, which could have a significant effect on your estate and what you're able to transfer, after you pass. So that's what I would be thinking about if I were talking and advising someone who is 61. These are the things we would, be addressing. So Next question here.
The next question is, does my family still have to go through probate with a trust? In general, no. And that's a benefit, one of the benefits of having your trust as estate planning tool is beneficiaries of your estate will not have to go through probate unless there are some issues and your trust needs court involvement. For example, successor trustees who were named in this trust are not available and there is no one nominated as successor trustee or things like that. But in general, no, trust allows you to avoid probate and distribute the assets without probate, without court involvement. It's more time efficient, and you still, with your trust, you can control, even after your death, you can control timing and manner of distribution. So if you want to distribute some of your assets outright, you can do that more effective than going through probate. If you need to keep some assets in trust maybe for the benefit of next generations, and next generations, maybe you want to provide your family members with additional asset protection. Maybe you want to create some kind of dynasty trust, lifetime asset protection trust. You can do all of that. You can keep property in trust for the benefit of next generations, and you cannot do that with last will and testament and probate process. So the short answer is yes, you can avoid probate with your trust.
I just want to add that certainly having the trust, if the trust is funded properly, right? So you want to make sure that you've connected your assets to the trust. So not just create the trust, but you absolutely want to fund the trust by connecting your assets, because if you have assets outside of your trust and they don't have beneficiary designations, and for those assets, you will definitely have to go through probate, and you'll use your will to do that. So keep that in mind, that the trust does allow you to bypass probate for the assets that are connected to the trust or have beneficiary designations. Are wills and trusts part of estate planning? So yes, absolutely. Wills and trusts are generally the centerpiece of your estate plan. A will or a trust is some combination. If you have a trust, like we mentioned in the last question, you'll usually have a will for circumstances that can arise that you don't have all of your assets connected. Maybe you bought a property towards the end, you passed suddenly, you didn't get to add it to the trust, or there are assets that are outside of the trust for whatever reason. Maybe they had beneficiary designations, then those beneficiaries pass, and now they're in your estate. So there's usually, when you have a trust, there's usually a will called oral will. Still needing to go through probate, but only for those assets that are outside. Now, of course, if you could have a traditional will package that doesn't involve a trust, but you can also have wills that have testamentary trust built in. So the centerpiece of most estate plan are the will and the trust. And even if you don't have assets, you're starting out and you don't have assets, still a good idea to have at least a will, because the events that lead to your death or cause your death to arise may give way to assets. For example, if you die wrongfully in a car accident, there may be a claim, and those funds are going to be part of your estate. So you always want to, sit and think about how you want your estate to be distributed if something happened to you. So yes, will and trust are definitely part of your estate plan, as well as your power of attorney, your healthcare directives, and your disability planning. So wills and trusts are more of your death planning, and your POAs, healthcare and financial, are part of your incapacity planning. There. Right.
The next question is, I have a will. When is it recommended to have a will and trust instead? And is will and trust document amount of wealth tribe? So as Sharline has already mentioned, that it's not about whether will is better than trust or trust is better than will. So the question is, what is the most appropriate estate planning tool for your family, for your estate plan. And sometimes it makes sense to move forward with your last will and testament as foundation of your estate plan. Sometimes trust makes more sense. And it's a case, it's individual, and it's hard to say what is the best, which one is the best. And although many people think that trust is just for ultra wealthy, that's not true. Basically, trust might be the best tool for your estate plan, even if your estate is not like millions or hundreds of thousands of dollars. Sometimes trust, you need to have trust if you want to preserve your house and make sure that it will not be used to pay your Medicaid expenses for your long-term care. Or sometimes trust is the best tool when you have just your like special needs beneficiaries, when you have minors, or maybe when you want to give someone right to maybe occupy your house for a few years after your death. So it's not about what is the best way to do your estate plan in general. It's about what is the most appropriate way to do your estate plan.
Yes, absolutely. When should you start estate planning? So there's I guess a short answer, or what I would recommend, is you want to start estate plan is something you want to, get started with as soon as possible, and go ahead and revise it as you get older, as your life changes. Because remember, estate plan is not just about death planning. So I know young people, you think I'm young, I don't really have to think about and don't want to think about dying, but it's also about incapacity planning, which can happen to anyone. So at 18, when kids are going off to college, I recommend to their parents, make sure they have at least a financial power of attorney and healthcare power of attorney. At 18, as soon as you become an adult, you can start thinking about these things. A financial power of attorney is a very useful tool for young adults. You go off to college or you're away from home, you're an adult. So your bank account is your account only. Your parents, no one will have access to that unless you give them access. So it's a good idea to go ahead and execute a power of attorney, making your parents or someone else that you trust, give them access in the event something happens to you. Those funds aren't just sitting there or become part of the unclaimed funds of the state of Georgia because you didn't give anyone access, or you didn't think to, because you didn't think anything was going to happen. So for every adult, you could start as soon as adulthood starts. Start the planning process. Start thinking about organizing your affairs. Estate planning is more of a planning tool. It doesn't have to be just your estate. And remember, like I mentioned, you may not have assets, but your death can cause your estate to have assets. So you want to think about that too. So you can really get started on estate planning as soon as possible.
What is power of attorney in general? So in general, power of attorney is the document that gives your agent, someone who was named as your agent, powers to act on your behalf in your best interests. So basically, that can be used to help you pay your bills, take care of your taxes, take care of your property, and these powers can be given immediately after you sign the document, or only in case of your incapacity. So sometimes it makes sense to have someone who can be your backup even when you can take care of yourself and your business. And sometimes it makes sense to just to make sure that in case something happened with you, in case you're in hospital, in case you are not available, you will have someone who can do that. And power of attorney allows you to do that.
So about that, I got a little got a little trigger happy there and went to the next question. Were you finished with that explanation, Igor? I didn't need to jump ahead. All right. Can I legally change my will between my siblings and wife? Can you legally change your will for any reason? Absolutely. As long as you are in your right mind, as long as you still have capacity, you can change your will. You will need to have the formalities in place that you did with the original execution. So, meaning it has to be two witnesses and the notary. The witnesses should be not related or not benefited under the will. As long as you follow those formalities, you can change your will for any reason. A change or to the will or amendment to the will is called a codicil, and you can make any changes that you like. Now, between, not quite sure what between my siblings and wife means. I don't know if that just means you would want to change the beneficiaries from your siblings to your wife or vice versa, but you can make any of those changes using a codicil to the will. I typically recommend that if you've amended your will more than 2 times in the past, to just go ahead and redo your will. Just because from a practical standpoint, you'll need to have the original will plus be able to locate each physical amendment or codicil. So if one of those get lost, we'll never know what the changes are. And so I usually recommend that, if you're on your 4th or 5th amendment, to just redo your will. But you can change your will legally as long as you have the capacity to do so.
Does a trust protect your assets in a divorce? So so first of all, you cannot, everyone needs to remember that you cannot use your trust to shelter your assets, to hide your assets from your creditors, to hide your assets from your soon-to-be former spouse. You cannot use the trust to hide your assets. So, and divorce is not, actually, it's not estate planning issue, because when you have your divorce, when you try to divide all your assets, in Georgia, there is a presumption that if anything, like asset titled in your name, that's your individual assets, but there are a lot of if. So if you bought these assets when you were in marriage, and if that's not your individual asset, and if you did not have any prenup agreement, and you was able to bought this asset just because you was married and your spouse contributed to your marriage, so that's tricky. So probably it might be affected by your divorce. So, but that's not about trust, because trust, you cannot just hide your assets, as I mentioned, in your trust. You can use this tool to protect your assets. You can create a revocable trust to separate your assets from your trust assets from your individual assets. However, if the main goal was just to hide from this divorce, and if your spouse does have a right to receive part, like interest in this asset, probably in court you will lose. But it's a tricky question. It's you cannot provide just general answer to this question, because each case is individual. So divorce is tricky. It's better to make sure that you have your agreement with your spouse, and you have individual assets, and if you want to treat some assets as individual, both of you need to be on the same page. Good. Sure. Well,
I mean, it's certainly if you have assets that you acquired during the marriage and you do like a joint trust or even a separate trust, that's going to be a different situation. But maybe if you're coming into the marriage with a trust, maybe from an inheritance, because inheritance, those are typically not considered marital property. So assets you bring in could be held separately. So like Igor mentioned, it is a difficult question to answer on its surface unless we have more specific facts. And estate planning and family law are two kind of separate trains. So typically we're doing estate planning to transfer assets to the next generation. So if you have created an estate plan for your children, and you pass away, so your children, now we're dealing with an irrevocable trust. These assets are already in trust, or, prior to them getting married, those probably will be protected as long as they keep it in trust and keep it separate. So there's a lot of overlap here, but the general answer is, for at least as a revocable living trust, there is no asset protection there, and you wouldn't be able to shelter those assets. And if you created the trust for a fraudulent reason to hide your assets from in a divorce, it wouldn't matter anyway. So how will POA affect me changing my will, which I included my sibling and wife? How will POA affect changing my will? So you, as long as you have capacity, you can change your will for any reason. A POA will not affect change in your will, because you're the only one who can change your will. However, if you have a financial power of attorney in place, your financial agent can affect how your will is carried out, because they can do things like move assets, sell assets. Your financial power of attorney can, for example, sell your home. So if in your will you gave your home away, or you changed the beneficiary designation, from one person to another, or whatever the case may be, but that house is gone because it was sold by your agent prior to you passing away. So now there's no house. Well, that does affect how the will is carried out. So your agent can close bank accounts, take the money out of an account that you were going to that you designated in your will to go to a particular beneficiary. So your agent can do things that can affect how your estate is going to be distributed and carried out, but you cannot affect the actual will, because you're the only one who can make changes to the will.
And I would like to add that POA is a document that it is effective during your lifetime. It does not work after your death. Your last will and testament will be effective only after your death. It's not effective during your lifetime. So basically, because sometimes, and we saw this misunderstanding sometimes with our clients. So if you was named as agent in someone's POA and that person passed away, the document is not valid. It doesn't work anymore the next second after this person died. So
yes, very good point there.
If a beneficiary is assigned on your account, so is it necessary to have an estate plan? So first of all, beneficiary designation is part of your estate plan. It's one of estate planning tools. However, in our opinion, it's not enough, because as I mentioned previously, if you have minors, if you have special needs beneficiaries, you cannot, it's a bad idea to designate them as beneficiaries of your account. And also, you lose control if all you did, all you have done is designated someone's as beneficiary of your account. Because what if this person passed away? What if this person predeceased you? Now you have an issue. So other estate planning tools, especially trust, can help you to control everything, and you can keep someone has been designated beneficiary for your asset and just add your trust as secondary beneficiary. So in case that person passed away, now everything will be paid to your trust, and your trust will control how these assets will be distributed after your death. So it's a great tool, but it is not enough.
I agree with that. All right. I think this is the last question. How much does estate planning cost? And the answer is it depends. It depends on what your goals are, what you're trying to accomplish with planning. It depends on who you're planning for, the different types of beneficiaries. We named, some here. If you have minor beneficiaries, then obviously we're going to need to be a little bit more deliberate and diligent in our planning. Or disabled beneficiaries also will require a little bit more attention. And it depends again on what you're trying to accomplish. Let's say, you don't want your family to go through probate. Well, now you're looking at a trust plan, which is typically going to cost more. So it depends. Will-based plan, and we say plan because it's not just a single document. So most plans include death planning as well as incapacity plan, like we mentioned. So you're going to have your will, you're going to have the POA, your financial POA, your healthcare POA at a minimum. If you don't have all of that, you haven't done planning, or you've only done one or the other. So you want to make sure you're covering your basis at a minimum. And those usually will, run from, individual documents, a couple hundred to maybe 1,000 or 1,500 or something like that. Your trust plans are definitely going to cost a couple $1,000 because there's just so much more that you can do there, and the more that you're trying to accomplish, then the more sophisticated your plan is going to be. The different class of beneficiaries, like we mentioned, more attention we have to pay to all of those, then of course it's going to increase the costs. And most of the times you can split that cost up over a period of time. And remember, even if you were to go the will-based route, there's a cost associated with probate. So sometimes with your will-based plan, you're just kind of delaying the cost. You're splitting the costs up. You do part of it now, and your beneficiaries are going to do, or your heirs are going to do the other part when you pass away. Typically with your trust planning, you're taking upon yourself to do your entire probate, your planning and your probate all in one. And so you're bearing all of the costs up front. So that's typically how the reason for the difference in the cost and why it costs a little bit more. So I think that's the end of our questions that were submitted beforehand. And now I just want to open up the floor for anyone that would like to ask any additional questions here. You can just go ahead and raise your hand, unmute yourself, and go ahead and ask a question. Does anyone have a question?
I do have a question.
Okay, wonderful. Hi, Michelle.
Hi. My question has to do with another email that I received from you regarding family limited partnerships and how they might tie in with estate planning.
Mm-hmm. Okay. Igor, do you want to shed some light on that?
So family limited partnership is a great way to combine your family involved business and your estate plan. So basically it can help you to not just control how your assets will be distributed, but it helps you to provide your family some continuing guidelines and to make it more clear how your family business should be run, and how your business will be run in case you pass away. So it can help you to avoid unnecessary conflicts between your family members. It can help you to create clear structure, how everything is managed, how everything is distributed, and so on. So that's a great tool to combine your family business and your estate.
Mm-hmm. And
it's really, so it's not like one size fits all. So in order to go deeper, we need to have more information, what type of business you have, what type of you have, and we can move forward.
Okay, thank you.
Mm-hmm. Yes. Yeah, the limited partnership, it is a wonderful estate plan tool, and it's a specific tool. So what we generally are talking about, the will and trust, those are foundational tools. 99% of everyone, even if you were going to use, other specialized tools like the family limited partnership, you're still going to have your basic will or trust or something like that, or some combination of the above. And then for other types of assets, like Igor mentioned, if you have a business, or let's say you want to pool your assets together, you have, you know, some family members have some assets that they want to, you know, take out, or particular goal that they're trying to accomplish for children, grandchildren, or whatever, and they can come together and form this kind of partnership. And there's some cool features here where you can, you know, bring in some of this, you know, the next generation and include them as partners, but limit their ability to, you know, to make decisions and things of that nature. So it's a very specific tool. It isn't going to work for everyone, but it, you know, that's one of the tools that we have in terms of planning. Yeah, so that's a good question there. And Ms. Beavers, you had your hand up.
Yes, and thank you both for your presentations tonight. Very informative and appreciated. I have my trust established, and just like you said, until I get my assets retitled into the name of the trust, it's just vacant there. So I've made an effort, haven't had a lot of success getting even the bank accounts. When I go, the representatives at the bank, they don't know how to do it. And everything that I have, except for my vehicles, has a designated beneficiary. So I went to the department of where you get your title to try to get my vehicles retitled, and they couldn't help me. So I was surprised, and so it's just very frustrating. They didn't offer any type of direction.
So this is something that we do come across quite a bit, and I feel it's just a little bit unfortunate because there is a lot of education that needs to be around trust. This is kind of a new, although it's been around for forever, it's new in our communities, and we'll still try to familiarize ourselves with it. And even sometimes at the institutions, they don't always have all of the information. To clear up one thing though, you don't need to retitle your vehicles. Your vehicles and your other personal properties like the household furniture and fixtures, artwork, things like that, those are grandfathered in or assigned to the trust with an assignment, a simple assignment document that should be a part of your trust package. So these questions that you're asking, the attorney or whomever drew that up should have, you know, gone through this and kind of given you some direction and guidance, which
Okay.
in our office, we always start off with education. So we're really big on making sure our clients understand what a trust is and what it is they need to do. So you don't need to retitle your vehicles. The big assets you want to make sure in your trust is your house, because unless you're going to add someone to title, then there's tax consequences in doing that. Trust is a great way to transfer your house and bypass probate. Outside of the house, like your other financial assets, you can do that with beneficiary designations. One of the only reasons, and so you can go to the bank and just ask for a POD form and ask to make the trust the beneficiary. And if you already have beneficiaries on that you're comfortable with, that you're okay with getting the funds, if something were to happen to you, you don't have to replace them with the trust. I would just add, at that point, just add the trust as a contingent beneficiary or backup beneficiary if something were to happen to those primary beneficiaries. So it's just about looking at your situation and seeing what is, what's best for you. Opening up an account in the name of the trust is something that I recommend, but it isn't absolutely necessary because your successor trustees, if your trust is created properly, and that's something you want to look at. Do you have successor trustees? You have enough mechanisms in place that if that trustee happen to predecease you, you have other trustees and ways to designate future trustees. Your successor trustees can open up accounts in the name of the trust. So there's just a few ways that you can go about it. But most banks, you have your certificate of trust. You want to go in, you want to present that. And that explains, basically breaks it down and tells them exactly what it is that the trust exists. Most times banks are skeptical if you just come in and say, you have a trust, because they don't know that you do. And there is fraud, and people also don't know what they're doing. So they'll say they have a trust and they don't. So with the proper documentation, and if you're educated enough to walk them through it, it's a fairly simple process. And I've had to get on the phone with banks and explain to them the process, because sometimes they do have a process. One thing you may run into is that they'll want you to have a separate tax ID number. And, there's ways to kind of get around that as well. Some banks you can't. So you have to decide, if I want to do business with this bank, I'm going to have to get a separate tax ID number if I want to open up a trust account. So there's a few things that you need to be educated on when you're going about trying to fund your trust. But they're all things that are part of the process and the educating process. And certainly if you're working with our office, these are things that our clients are familiar with, and they know what questions to ask, and they know to come back to us if they're having a problem.
Okay. Okay. I got my house transferred without any problem, but it was just the vehicle thing and my, my bank assets. But they told me they didn't know anything about it. They didn't know how to do it, and that was it. So thank you.
You're welcome. You're welcome. So you don't need to transfer the car. You don't need to transfer the car into the trust, as long as you have your assignment, as long as there's an assignment document in your packet. And with the bank, you can just add the trust as a beneficiary. And that would suffice.
Okay, thank you.
You're welcome. Any other questions? Igor, did you want to add anything to that? Did I miss anything there?
No, you did a great job. I just, unfortunately, you need to connect all your assets with your trust, and sometimes that's not the matter of your trust. That's just the matter of this bank and this officer, and they just don't know what to do. But many banks, they allow you to add your trust as designated trust as beneficiary of your estate of your account. You can do that online without even visiting the bank. But it really depends what bank you use.
All right. Any other questions? We have someone coming in. Good evening. Good evening. Oh, this is coming in the trust. All right. Okay. We just had someone joined. I was joining in. I wanted to, maybe they had a question. All right, no questions, guys. This is a great opportunity to get your questions answered, sorry. To ask your questions so they can be answered. You're welcome. All right, well, if there aren't any additional questions, then we're gonna wrap it up. We won't keep you. We've answered all the questions that are here, and you guys don't have any additional questions, we will call it a night. And thank you so much for joining us for our monthly webinar. And we look forward to seeing you. Tell a friend. We try to forward to our list the flyer with the information for each month. Next month, we will have a guest speaker who will talk to us about more on the elder law planning side and the various insurance tools that can help you with long-term care planning. Had a conversation with him. Mr. Patrick Davis will be our host for our speaker for next month's webinar, fourth Thursday in the month. And he had wonderful information how to help seniors plan for the future and using various tools there for long-term care planning. And so really excited to get that information to you. So tell a friend that you think could benefit from that, seniors, and this is a really useful tool. I see a lot of my senior clients who don't have any type of insurance, long-term care insurance, because of course, if you don't get that fairly soon or earlier on, it's very, very expensive, and not a lot of providers even have long-term care insurance as a standalone policy. Although you can combine some of your life insurance with living benefits and things of that nature. They're just some wonderful tools that he exposed me to, and I definitely want to get that information. So tell your friends, your seniors to come out and get some information about that, how to protect yourself, how to utilize these tools to ensure that you can preserve as much of your estate as possible to transfer to the next generation, because you'll have funds set aside to take care of if you were to get sick and needed more care. So if there are no other questions, I'm going to wish you guys good night. Thank you for being here. Thank you, Igor, for lending us some of your time and answering questions for our community. This is a free service we offer because we want you guys to be informed, and we love giving back to the community. So thank you. Thank you. If you need tools or need more estate planning, want to see us, please reach out. Our contact information was up just a minute ago. I'll go ahead and put it up again just so that you can see it. This is our contact information. Reach out, get your planning done. Like I said, as long as you're an adult, 18, you really can do your will starting at 14. But for things like a trust, you're going to need to be at least 18 to do. You can get started there. So there's really no excuse not to have this in place, and it's very important for your family that you have thought about, sat down and thought it through, and make sure you're making the best decisions for them. So again, thank you, and we will wish you good night. We'll see you next month. Bye-bye.